Thank you for listening to the Isn't That Legal podcast, a legal podcast for non-lawyers. I'm Steve Flores, and I'm a lawyer, and I know my stuff, but there are a lot of different areas of the law that I'm unfamiliar with. So on this podcast, we bring in lawyers from different areas to come in and talk about what they do in a way that's easy to understand. One thing that's important for all of us to remember is that laws change all the time, and that we elect the people that write those laws. So if there's something that's unfair or doesn't make sense to you, you should organize, get together with like-minded people, vote, and make sure that you hold your legislators accountable. Before we get started, it's important for you to understand that we're going to be talking about the law and how lawyers work, but we're doing it for entertainment purposes. We are not providing legal advice, and you should not rely on the discussions we have for legal advice. If you have a legal problem, it's really important for you to hire a lawyer to help you with that. On this episode of the Isn't That Legal podcast, we will be talking about personal bankruptcy. My guest is Claudia Badillo, who is the owner of the Badillo Law Group, PC. Claudia represents individuals in personal bankruptcy as well as other areas of the law. Claudia, welcome. Thank you so much for joining us today.
Thank you. This is great. Any chance that I get that I can talk about bankruptcy, I'd love to help.
Wonderful, wonderful. So tell us a little bit about yourself.
Sure. So my name is Claudia Badillo, and I do have my own firm. I'm a solo practitioner. I have an assistant. But essentially, I've been doing bankruptcy for over 10 years. I've been an attorney, actually, 12 years now. I keep saying 10 years, and I kind of stopped it at 10, but it's been 12 years.
Yeah.
So I actually even practiced bankruptcy while I was in law school. So I clerked at a bankruptcy firm, and I just stayed. I ended up loving it. And a little bit about me, my mom is Colombian. My dad is Mexican. I was born here in Chicago, born and raised in Chicago, product of the Chicago Public Schools.
Yeah.
I went to Northwestern University and Chicago Kent Law School.
Okay.
But yeah, I have been honestly doing bankruptcy the entire time. I clerked a little bit in law school for the public defender's office at 26 in California.
Okay. Oh, interesting.
Yeah, that was fun. It was in the felony trial division, so I got to do a lot of hands-on criminal defense. I even got to do opening statements at a jury trial.
Oh, interesting.
Yeah,
okay.
Yep, very nerve-wracking.
When you say you clerk with them, that's basically you help out the lawyers that are working.
Exactly, right. So you essentially are assigned an attorney, a public defender, and you're his or her clerk. You're still in law school, but you get this fancy thing called a 7-Eleven law license where it's like your driver's permit where you can practice law under the supervision of an attorney. So you basically have all the rights an attorney has as long as they're in the courtroom supervising you.
Interesting.
Which is fun, a little daunting for a young law student, but you learn a lot.
Yeah.
We actually visited inmates and defendants like in the lockups and in the jails. And we did a lot of preliminary hearings, a couple of jury trials where I got to cross-examine some police officers.
I mean, that's an amazing experience to be able to do that before you're out practicing in the world.
And what's funny is I always thought I wanted to do criminal defense. And even though I enjoyed my time there, I didn't love it as much as I love bankruptcy.
Interesting.
Which I discovered while clerking at a bankruptcy firm, also in law school. And so I just
Okay,
stayed.
so you had a little bit of a taste of the bankruptcy practice. Okay. Did you always know you wanted to be a lawyer, or?
It's funny, and I know this is very cliche, but yes, I actually found recently, my family and I just moved, and so we were looking through boxes, and I found my 8th grade little like signature yearbook where people sign and you write what you want to do. And I wrote back in 8th grade that I wanted to be a lawyer.
Wow.
And I actually didn't remember that. I didn't remember that I had written that because I kind of thought I've always wanted to be a lawyer, but that's proof. It's proof that I genuinely have always wanted to be a lawyer.
That's why you're probably the first person on this podcast, I think, who like that's what I wanted to do.
It's crazy. I don't know why. And you're just a child. You don't know what being a lawyer really means. Right. But apparently that's what I wanted to do. Maybe I watched too much TV.
What undergrad did you get?
Communication studies. Yeah.
Okay.
So I went to Northwestern, majored in communication studies, minored in history. Kind of a general,
Okay. Yeah, I've got my son asked me, or kind of what kind of undergrad, and and on this podcast we hear, and I'm a poli-sci,
Yep.
and almost every lawyer is a poli-sci who comes in. But I don't think poli-sci prepares you or really gives you any skills that are good for a lawyer. I think
Not really.
I think a
communication
degree.
studies helped a lot. We actually had like a speech writing class, which was really helpful. Although you don't quite write speeches, but it prepares you for public speaking, which is huge. I mean, if you're an attorney, unless you're strictly transactional, I mean, you're going to court, and that can be pretty nerve-wracking.
Even your written communication, right? Short, to the point.
Absolutely.
Right. That's learning to write well. I think
that was
and
huge.
Speak well is
so
huge.
I think that's a really good piece of advice for people who want to go to law school or become attorneys. Is you really you're writing motions, you're writing letters, you're drafting important correspondence. So you want to have really good grammar, right? You don't want to have typos, and you want to be able to express yourself
short, concise,
right,
to the point,
and describe a lot of these terms that are in legalese that people don't understand, and make it so that your clients understand what you're saying. So I think that's important.
Yeah.
Good writing, lots of reading too, right? How much reading did we do in law school?
Right.
Hours and hours of reading.
Right.
So
right. That's the big shock. It's like, okay, now you have to read like 100-page case, 100-page case
by tomorrow.
Right. And then be ready to be grilled on it and not know what you're doing at all. I mean, I did not love law school.
You know what? I can say I definitely didn't love law school either, but
it's like a boot camp, I think.
I think it is, to make sure that you really want to go through with being a lawyer.
Right. So you wanted to be a lawyer, and then you did have the experience both to try, which I think is invaluable because law school and classes are nothing like the actual practice of law. So you got to actually practice a little bit in the criminal context. You got to see what was happening in the bankruptcy context. So you knew right away, okay, that's what I'm going to do when I come out?
I actually did, because that's the firm that hired me. So where I was clerking in law school happened to be a very small bankruptcy firm, and I was invaluable because I spoke Spanish. So my boss did not speak Spanish. He kind of speaks enough to get through maybe a consultation, but I learned right away that, if you can communicate with your clients in Spanish and English, that's a huge asset. So I ended up staying, and this was back in about, I'd say 2000 and prior to 2005. So it was maybe 2003.
Okay.
And that's when I think I graduated college. I don't remember anymore, but that is, for people that don't know, there was a big change in the law in bankruptcy in October 2005. It's when the new bankruptcy laws basically were created, right? And fixed up, so to speak. So prior to 2005, things were very different. And it's funny because I actually got a little taste of the it's called BAPSIPA is the new law, the Bankruptcy Abuse and Prevention Consumer Act.
Okay.
And that went into effect in 2005, which is actually pretty recent. So before BAPSIPA, in around 2003, 2004, I was clerking at this firm.
Okay.
And we were pumping out cases in 10 minutes. You would meet with a client, sign a petition, file it, look at some...
you know how it
right,
works.
you know how it works.
You've done it a million times.
And you look at some pay stubs and boom. Now, when the law changed in October, I think, I might be wrong, but I'd have to double check, but it was either October 15th or 17th, 2005. I remember it was like a Friday and the law changed that Monday. So we were working in that office filing the last 10, 15 cases we could file before this huge change in the law. So it was really interesting because I got to be there as a law student prior to this new law being enacted. And then that Monday, or even before, because you as an attorney, you get this information beforehand, right? You can see the act ahead of time. My boss kind of, I think back then we had a book or printed it out or something. And he was like, here you go. Here's the new law. See you on Monday. Everything changed. So the world in bankruptcy, as we know, it changed dramatically in 2005. And a lot of attorneys stopped practicing bankruptcy because it was a huge, basically what the new law did is just establish these hurdles for people to file. Okay. So before, there were income guidelines, but then now after the law, there were actual set income guidelines. There were new forms that needed to be filed. And basically it was providing more proof to prove that you qualified for bankruptcy. Whereas before you kind of just said, oh, hey, I qualify, and as long as you didn't really have much in assets and your income was okay, you were fine. But the new law really made it so that you had to submit a certain amount of documents and information to the trustees. So made things difficult, but
Okay.
it's okay.
So I mean, it's kind of, it's bad because it makes it more difficult,
Right.
maybe, but it's good, I guess, for a young lawyer because you can like really
Exactly.
own it and learn
I
it.
was there when the law changed.
And you haven't been doing something for, 30
Exactly. So
years
for
a
me,
certain
for my
way.
old boss, it was a very huge change for him. He had already been practicing for a while, but for me, I wasn't even licensed yet. So for me, I've only really known
Yeah.
the bankruptcy world, post 2005.
Yeah.
So.
Oh, that makes sense. So say somebody comes to your office, like, what are you looking for to determine, okay, this is going to be a good fit. I'm going to take this person on as a client.
So, and actually the funny thing is that we would normally schedule an appointment. Like there's a way that attorneys, do things, and it's a very personal decision for attorneys. I've worked at places, with my old firm, for example, we would immediately set up an appointment. We wouldn't really screen callers. We would get them into the office, sit down with them. Now, especially with, of course, COVID-19, you're not really doing that anymore. And so, but the way that I've been handling my business, at least for the last couple of years, is I do so much of my screening of clients over the phone because, you can find out so much information just by asking some simple questions. So the first thing I usually do when people call is I just start asking them. I just have a script already in my head.
Yeah.
My assistant, for example, if she takes the call, she has her script. And I'm just finding out information. I just want to know. Most of the time, people want to tell me their story, and that's okay. So if I have a client who I feel like they really want to tell the story, I let them tell the story and I jot notes. But I do try to kind of control the conversation a little so I can get the best information.
Yeah.
So for example, I always ask if they filed bankruptcy before. It's very important because there are very strict rules as to when you qualify for bankruptcy.
Okay.
So, Chapter 7 bankruptcy is the type of bankruptcy that most people know about where you just eliminate your debt. You walk away from your unsecured debt, such as credit cards, medical bills, you walk away.
So there's different kinds
Different
of
types of bankruptcies.
Okay. Yeah.
Basically, you have your Chapter 7 bankruptcy, which is a dissolution. It's you're just telling the court, look, I don't really have enough money and I don't really have enough assets or any assets to pay my debts. Here are my debts, and they're wiped out. Okay. So that's a simple kind of the one everyone wants to qualify for.
Right.
Then there's Chapter 13, which is also for individuals, right? We're not talking about business bankruptcies, although a business could file Chapter 7 to dissolve. So if you had a business that was that ran itself into the ground, you could, wind it down with a Chapter 7.
I see.
You don't need to always. But these are individual bankruptcies. So Chapter 7 really is for individual debt. Your own credit cards, your own medical bills, personal guarantees on business debt, which is huge because if you sign a lease for a small business, I promise you, unless you're a multi-million-dollar corporation, you're personally guaranteeing that lease.
And that means you're backing, if the business doesn't pay the lease, you are on the hook
personally
for it.
are on the hook, which means that they can attach a lien on your house. They can garnish your paycheck. They can sue you personally for that default. So those are the types of debts that people kind of don't think about that I'm always looking for so that they can wipe out that debt in Chapter 7.
I see.
So it's not just, everyone thinks that people file bankruptcy for credit cards or medical bills, but there's so many other types of debt. Personal loans. If your cousin lends you $10,000 and you wrote up a little contract, you can discharge that debt in a bankruptcy. That's a regular unsecured debt.
That's probably
People
not
do
going
it.
too well on Thanksgiving, but
Exactly, right. Your cousin might not be too happy about it. But it's funny, but I have to bring that stuff up, especially with a lot of our Latino clients, because a lot of times they do get these personal loans, and they're dischargeable.
kind of more informal lending happening.
Exactly.
Yeah,
so I always ask about that, and those are things that don't have any you don't have a statement to show. It's not on your credit report either. So when I pull someone's credit report and I look at all their debts, the debt to your cousin isn't listed on your credit report.
Yeah.
Right. So I'm always looking for debts. That's kind of my first question to people. Why do you need to file bankruptcy? Why do you think you need to file? And they kind of tell me their story, and I'm writing down the amount of debt. Credit cards, medical bills, unsecured debt, such as payday loans. Those don't report usually to credit reports. Hospital bills surprisingly don't report to credit reports unless you're behind, and it goes to collections. So usually if you have a big medical bill, if you just incurred that debt, it might not hit your credit report. So I need to see bills. So hospital bills, personal guarantees, car deficiencies. So a lot of my clients have had their cars repossessed
Okay.
because they co-signed for someone, for example. So you
Oh,
co-signed for your brother, he moves to California and he doesn't make his car payments, and they come after you.
Yeah, I've
So-
had some co-signing issues myself with people.
Deficiency
Don't do it.
balances. Yep. Don't ever. Oh, are we talking advice? Do not co-sign. Oh, I have a list that would fill an entire office space. Don't co-sign. That was really important. Or if you do, just make sure you understand that co-signing does not mean that you're 50% liable for that debt.
Right.
It's
or that you can even
100%.
get the car if
Yeah.
you, right?
You are both owners of that car equally, and you're both on the hook for the debt equally. It's 100%, right? Joint and several liability. We learned that in law school. But so, those are things that I'm looking for. Car
Okay.
deficiencies, car repossessions. Foreclosure deficiencies is a big one that people
Okay.
don't realize. If you lose a house in foreclosure and you're underwater on that loan, that so many people are,
Yeah.
you could be on the hook after losing your house
Mm-hmm.
for $100,000 to Bank of America. And that's called a deficiency.
That's
And-
been, your house has been repossessed,
Yep,
resold.
it's been
but-
taken
Okay.
from you, but the bank didn't make enough money at the foreclosure sale to recoup their
Oh, I
their
see.
con.
So they're gonna come after you.
They're going to
get
come
it.
after you. And Illinois is a recourse state. We call that recourse versus non-recourse. And Illinois is a state where you can have that personal liability.
Oh,
And that's
interesting.
huge because at that point, if a person tells me they have $5,000 of debt, well, maybe you don't need to file bankruptcy. But if you have a house that you lost and you're being sued for $100,000, I mean, that's almost silly not to file bankruptcy at that
Right,
point
right.
because you're never going to be able to
You
pay
don't have
that
a
debt
house
back, and you don't have a
you're
house
out.
anymore.
Yeah.
So that's a very good example of why someone might need to file. So we ask those questions after I figure out what their debt is, and there's certain debts that are not dischargeable in bankruptcy. So they might tell me they have $50,000 of student loans that are killing them. Unfortunately, without showing a very, very significant hardship, you're not going to get that discharge. So that's my goal, is to figure out, kind of make a list.
Yeah.
Dischargeable, not dischargeable. Taxes are tricky. Some IRS debt is not dischargeable, some is.
Okay.
It depends on the years filed. There's very strict rules as well.
Okay.
Usually we have to pull tax transcripts to determine that. Debt to the state of Illinois, the Cook County, right? County departments.
Yeah.
You can have debt to
All
any
over.
agency you've ever heard of, right?
Yeah.
Building code violations. My clients come to me with $10,000 of building code violations that they have on a property that they lost already. For example, parking tickets are another huge one. You can, even though I know that our mayor and some other officials have said that they won't suspend licenses for tickets, they still are in certain cases. And there's still clients with their license suspended due to parking tickets and other administrative judgments. So that's a big one because bankruptcy can actually reinstate your license. So
Okay.
if you were to file for bankruptcy, depending on whether you qualify,
You get rid of the
you
tickets.
get rid of the
and other
tickets.
things. Oh,
And that's
interesting.
super new. There's a new program with the city of Chicago called the Chicago Fresh Start program that
Yeah.
started last year. I believe it was January 2019. You could not discharge parking tickets before. And to give you some idea of why this is a problem, because many of the people listening might say, well, yeah, parking tickets. Yeah, okay, I have $200 in parking tickets. No big deal. I have clients with $10,000 of parking tickets, $5,000 of parking tickets. The city of Chicago collects tickets from the 1980s and the 90s.
Wow.
There's no statute of
And
limitation.
there's interest probably on all their penalties or something.
There's
yeah.
interest. There's not interest, but there are penalties or fines on top of the ticket, right? So a $100 ticket usually doubles. It usually doubles, and that's it. But
Okay.
that's still a lot. So I'm not kidding that I have clients with $10,000 of parking tickets.
I
So
guess once you're like at $4,000, you're like, whatever.
Right. Well, or you let your girlfriend drive the car, the boyfriend drive the car, your son drove the car.
Yeah, and
So
nobody tells you.
And nobody
Yeah.
tells you. So tickets are a big one.
Wow.
Tollway violations are another big one, and this is not an exaggeration. I had a man with $120,000 of tollway violations.
How did that?
That is mostly fines, and don't get me started with the tollway. The tollway assesses, you go through, it's 20 cents or 40 cents, and then it's like a $20 fine on top of that. So that accumulates quickly.
Wow.
And then we have people with trucking businesses. So now you're talking CDL truck drivers, taxi cab drivers. They're on the hook. It's crazy. So, we're looking at the kind of debt we have. I'm making my notes,
Okay.
writing my notes. And then I want to know what their assets are.
Okay.
And what that means is, what do you own? That's literally what I ask people. What do you own? What do you have that has value, right?
Okay.
your furniture at home, nobody wants your furniture, right?
Yeah.
There's something called exempt assets and non-exempt assets.
Okay.
So even though bankruptcy is a federal process, it's actually filed in federal court here in the Northern District. We e-file everything. In Illinois, you can protect assets with your state exemptions. And what that means is that there's a list of exemptions. That means that you can keep certain stuff.
And that's different from state to
It
state?
is totally different from state to
Okay, so
state.
federal law governs,
Governs.
but they say whatever the state says.
For your exemptions. Now, there are federal exemptions.
Okay.
But, and this is now we're getting into a whole slew of, but in the federal exemptions are different than the state exemptions.
Okay.
But you cannot use federal exemptions in some states. In Illinois, you are not allowed to use federal exemptions. So I don't even look at them, to tell you the truth.
Wow. So the state says,
the state of
this
Illinois,
is the list we want
this
you
is
to
it.
use.
It changes in Florida, Texas, and some states you can choose. You can choose your state exemption versus your federal exemption, whichever is better. So here's an example of what I mean. So you have a car exemption in Illinois. You can own one vehicle and the court won't take it away from you, right? Because you need your car to drive.
No matter how much you
Well,
owe? Or,
no, yeah, I wish.
Okay.
So I have a guy who, for example, he's like, you know what? I have a truck. It's a 2010 Dodge Durango. It's in really nice condition. It's got and these are true stories. It has a, the hookup for the snow plow because I clean snow. Yeah. It's beautiful. I keep it real clean. It's got about 50,000 miles on it. And it's worth about $10,000. Unfortunately, that client won't qualify for Chapter 7. The Illinois exemption for a car is $2,400, which is a joke.
Wow.
A lot of them are these exemptions are very outdated. So $2,400 for a car, which means if your car exceeds that amount, you might risk losing that car if you file Chapter 7.
Interesting.
So those are questions I always ask. I want to know about their cars. I want to know. Now, if the car has a lien on it, like most people do, you're paying Toyota. You don't even have the title. Who's got the title to your car? I ask people. Oh, Toyota. Oh, yeah. So you owe $10,000. The car's worth $5,000. Not an issue, right? Because you don't have any equity in the car. There's no value in that car to a trustee in bankruptcy court. Go ahead. Keep your car. Just keep making your payments. That's another thing. People think that they can just keep the car and not make payments. You must make the payments on your car to keep your car. I don't care what type of bankruptcy you're in.
Oh, really?
So there are people that think that that's not true. File bankruptcy, and 3 months later they call me. They're like, well, I got a call from my finance company. They said that I have to make my payments. I'm like, well, yes, we discussed this. You have to make your payments to keep the car. Same with your house. You have to make your mortgage payments to keep your house. And so we're asking you about cars. Furniture. So you get $4,000 of what's called a wild card exemption, which is what it sounds like. Anything. $4,000 of stuff.
Okay.
But guess what? $1,000 worth of furniture.
Yeah.
Maybe you have $500 in the bank. Maybe you have a piano, a violin. I mean, that's used up pretty quickly. Most people have just about that much.
You get to pick and say, this is...
Yes, you get to pick. But of course, I want to make sure that my clients can protect everything, right? Nobody wants to lose anything in bankruptcy. Right. So that's my priority, to make sure that my clients don't lose any assets.
Figure out if they filed before, figure out what their liabilities are, figure out what their assets are. Yeah.
And the same goes with their house. The houses are really important because honestly, your house is most of the time, that's your most important asset. Yeah. And that's your most valuable asset. So if there's any equity above, and here we're back to the exemptions in Illinois, above $15,000 of equity in your house, you risk losing the property. It doubles for married couples, but it only goes up to $30,000. Okay. So no matter what, if it's a husband and wife and their house is worth $300,000 and they owe $270,000 on the mortgage, we're okay. Because, when you sell your house, you got to pay closing costs and you have to pay a realtor and broker's commission. So by the time the house sells, the question is, will there be money left over above and beyond your $30,000 cushion of protection to pay creditors? If the answer is yes, you don't qualify for Chapter 7. And a trustee will actually sell your property and liquidate that asset in a Chapter 7. It's a liquidation. So my job as an attorney is to protect people's assets and is describe the risk. And if it's too risky, I have people get comparative market analyses on their houses. You get a CMA from a realtor to be certain that the value doesn't exceed whatever amount we're aiming for.
Okay. Okay.
If it does exceed that amount, then we start talking about Chapter 13. So
Okay.
Chapter 7 is for my clients with very little assets or exempt assets,
Okay.
protected assets, normal stuff, right?
And that's Chapter 7? That's
Chapter
where you
7.
kind of get rid of everything.
And that's the reason that the test is so hard, because they don't want you to have $10,000 in the bank and you're eliminating $10,000 of credit cards, right? I always ask my clients, what could you sell off to pay your bills? And they think, and they're like, well, I could sell my TV for $100. So if the answer is, well, I don't really have anything to sell off, then you can probably file a Chapter 7.
Okay.
Some things are fully exempt. Retirement accounts are exempt into the $1 million mark. So, retirement accounts are okay.
Social Security.
Social Security, right? Okay. Even lump sums of disability for Social Security. So I had a woman who was waiting for $100,000 Social Security settlement, disability settlement. That amount is exempt. That can hit her bank account, and she can still file bankruptcy and discharge her debt.
As long as she can show that this is where
you have to show very
from.
Carefully, right, where that money came from. So workers' compensation proceeds are exempt. Okay. So again, that is very common. I constantly have clients who have workers' comp settlements either coming or about to receive them, and you can protect those workers' comp proceeds. Okay. So that's really important. Some things are not protected, like personal injury lawsuits. I had a client call me a couple days ago he was in a motorcycle accident and he was pretty injured. He's going to get about $60,000 of proceeds.
Yeah.
Illinois exemption. Guess what it is? $15,000 for PI. Mm-hmm. Okay. So if that exceeds the $15,000, which it's going to in his case, he cannot file Chapter 7. He will lose that money. So the trustee will make him liquidate that money and pay creditors with it.
Okay. So I guess that's just thinking through the biggest distinction. It seems like if you have anything that is above those exemptions, then you're prohibited from filing Chapter 7.
I would prohibit them from filing. So that's a really good question, because no, you can file a Chapter 7 and have all the assets in the world, but they're going to be liquidated. Okay. Now, some people take that risk. Some people say, you know what? My car is okay. It's worth $10,000. Good luck selling it, because you might think it's worth $10,000, but when a trustee takes a look at it and determines that there's no buyer for it, it might not be worth 10. It might be worth 5. And if it's too much work for a bankruptcy trustee to liquidate the asset, and there won't be enough proceeds to really pay creditors, what they'll do is they'll abandon the asset.
Okay.
So that's kind of my job, to teach people what the difference is between, keeping an asset, abandoning an asset. The big takeaway is that once you file Chapter 7, once I push that button and you file that case, you don't have a choice anymore as to what to do. Once that case is filed, a bankruptcy estate is created and the trustee takes over. So
when you say trustee, so there's a bankruptcy judge.
There is a bankruptcy judge.
But he assigns it to a bank or something?
So usually what happens is when you file Chapter 7, at least here, you're automatically assigned a trustee, a local Chapter 7 trustee. Okay. It's about 20 in Cook County, I think. And that it goes by county of where you live. So DuPage County has its own trustees, Cook County, Lake County. Okay. So assuming you're in Cook County, you automatically, I can't pick, right? You automatically get assigned a trustee.
I see. Okay.
That trustee is not a judge. And that's the most communication you're going to have is with that trustee. Okay. You actually, in Chapter 7, never even meet the judge.
Really?
I know who your judge is, and you're assigned a judge. If there are issues, or if there's a motion filed or some kind of problem, then we go in to court to see the judge.
I see.
But in a very easy, typical Chapter 7 case, my clients, who are also called the debtors, because they have the debt, they do not meet the judge and they do not go to court. They have one very informal meeting with the trustee.
Okay.
It's called a creditor's meeting. Okay. So that's something that most people are surprised about. They think they have to go to court and, stand there. And now you do testify, but the meetings are short. They're under 10 minutes. Wow. And they're just verifying what we've already done, which is listed the assets.
That's what the trustee's doing. Here's the assets. Here's the liabilities. Yep. And you're trying to make sure, hey, of the whole universe of potential liabilities that you've got out there, we want to get that all in.
Exactly. Yeah. And that's tricky because people come to me with garbage bags of bills. Also, sometimes people, they don't remember where they've gone. They could have had a hospital bill 10 years ago that they stopped collecting for, but that doesn't mean you don't owe the money. Right. So it's difficult. I try to tell people to make a list Credit reports are wonderful, but they're not perfect.
Yeah.
You know, like I said, a lot of things don't report to credit reports. So
Yeah.
we kind of, I have a list, and I encourage people to try to remember where they went, go through old mail,
Yeah.
you know, and do your best to list
And
all your
then-
creditors.
So the trustee then, okay, I've got the list of assets, asset liabilities. Their job is basically, okay, what can we sell
You
to
got
come
it.
up with money to pay off
You got
the
it.
creditors?
And that's
Yeah.
basically their job. Their job is to look
Okay.
for assets. And so also, of course, they do other things. So what we haven't talked about yet is to qualify for bankruptcy. Also, the trustees and myself, we're looking for other things as well. I want to know, well, we didn't even talk about income. So
Yeah.
the second part to the test for Chapter 7 is income.
Okay.
Of course, you can't come to me and make $300,000 a year and wipe out $50,000 of credit cards.
Okay.
That doesn't seem fair, right?
Right.
The general rule is that if you have the ability to pay your debts
Yeah.
and still live comfortably, you don't qualify for Chapter
I
7.
see.
And that's where this thing called the means test, means like the word average, comes into place. So that was one of the big changes in the law in 2005.
Before that, you didn't.
No means test. You kind of just showed your pay stubs and did a budget and submitted it to the court. And you said, hey, I make $5,000 a month, but look, I spend $5,000 a month. I can't pay these credit cards. And there was a reasonableness test, right?
Okay.
Now, there is still a reasonableness test, but it's also a very strict 6-month look back period. So
Okay.
I need to look at people's pay stubs for 6 months to see what their average income has been and what their future income will be, and we create a budget. A budget like everyone should create, right? What do you pay for food? What do you pay for mortgage, car payment, school, etc.
Right.
And at the end of the day, if you still have $500 left over, you know, you might not qualify for Chapter 7. And there are very strict income guidelines.
Okay.
And they change every
But
year.
if you're not making that much,
So under
and-
$50,000 a year for a single person is about the cutoff.
okay.
You're okay. It increases with family size. So if you have a family size of 4 or 5, you can actually be making gross family income. Remember, spouses,
Everybody.
income counts. Everybody in the household, which is usually, the spouses, 2 spouses.
Yeah.
If you're making under about 100,000, a little bit more, family size of 4-ish, you should be okay.
Okay.
It's my high income earners that are difficult. You know, high income earners, I consider anyone over 150,000 a year for bankruptcy purposes. Then we really start looking at budgets, looking at taxes, and being more careful. And I have to run the test.
I see.
If I run the test and they don't qualify, you're looking at Chapter 13.
No Chapter 7.
No Chapter 7 for you. So
Okay.
low assets or exempt assets are good. I call it low income, and we're okay. Trustees are also checking for other things, fraudulent transfers. And these are things that clients never think about. So fraudulent transfers could mean that you come to me and last week you just gave your mom $10,000 because you owed her money and you love your mother. And you're like, well, listen, I'm going to file bankruptcy and these are my last $10,000. I better give this to my mom.
Right.
That's a fraudulent transfer. It's
Even if you owe her money?
Oh, especially if you owe her money, because that's So that's actually called a preference payment as well.
Oh, I see.
You are preferring her as a creditor. Remember, your mother is just like American Express and Discover Card. She lent you money. American Express lent you money, but you preferred to pay her versus American
You
Express.
don't get to say who
You
you're
don't
gonna
get to
pay.
say. So if I file the case, and I didn't ask about that, which I always ask, but sometimes the clients don't disclose it. Now, you have to tell the truth at these meetings, right? Under penalty of perjury. My clients are sworn in at their meeting. So that's your risk to take, right? Very, very serious penalties for not telling the truth. And sometimes these things are show up on bank statements. So trustees look at bank statements for 2 months at least or more if they think there's an issue. So once I look at bank statements, so that's something I'm very carefully looking at, bank statements. And if I see $10,000 going out last month,
Red flag.
red flag.
Yeah.
Where did you spend this money and what did you do with it? And a trustee can sue your mother to get the money back into the bankruptcy estate. And the trustee would distribute that money equally amongst all creditors and take a little percentage for himself or herself.
Okay.
So that's the the momentum, or the not the momentum. That's the reason that trustees are looking for assets as well. They get paid a certain percentage for finding assets and distributing
okay.
these assets.
Okay. So you're aligning interests by everybody's, well, I guess the creditors and
Well, the trustee, I always tell people the trustee's on the creditor side,
yeah,
right?
yeah,
And you're the debtor. So, and a lot of times creditors don't object to bankruptcies. So if you just have a bunch of debt to American Express and Discover and Bank of America, and you haven't racked up, $10,000 of debt last week either, because that's another red flag. I want to make sure there's no recent usage.
Oh, that you, yeah. So you go out. Yeah, that was going to ask you about that. So yeah, like if you go out and you're like, I'm going to file for bankruptcy, so I'm going to go get my TV, I'm going to go get all my stuff.
And I'm not going to pay for any of that.
Yeah.
That's a fraudulent. There's fraudulent intent, right? If you intended to deceive creditors, now the creditors have to prove it, of course, right? It's the burden of proof is on the creditors.
Yeah.
However, in that 90-day period before the filing, it's pretty much presumed to be fraud.
I see.
So anything older than 90 days, the creditors really have to prove it, because how do you prove that the person intended to file bankruptcy, right?
6 months from now.
6 months, right?
Yeah.
Things happen, right? And then you're pretty safe if you use credit cards in the last 6 months. But if you're using them right before the filing of the case, you're going to get asked about that. Okay. And those are the questions that I ask people. Normal usage is usually okay. But big expenses, big luxury purchases, cash advances are the worst. Those are definitely difficult to overcome that presumption of fraud.
Yeah.
Now the creditor has to bring a lawsuit in and we have to defend it. But those are things I always ask about. Transfers, sales of property before you filed for bankruptcy. Have you sold, transferred, or given away any property in the last 2 years is a typical question asked during a creditor's meeting by the trustee. So if you sold your house last year, you made $50,000, and once again, where does that $50,000? Now, if you used it in the normal course of living your life and you paid some food and gas and you did pay some creditors, but not with the intent to file bankruptcy, and it was over a year ago, you're probably safe.
Okay.
But if you hoarded the money and gave it to your brother to hold, those are going to be problems.
So in Chapter 11, where we're kind of getting rid of our expenses, two things. I guess one, you said student debt, and this is always something that a lot of folks are not happy with, for kind of more from a policy perspective.
Sure.
But student debt is one you cannot get rid of unless.
Oh, it's really tricky. So student loans. So in a Chapter 7 bankruptcy, essentially you're eliminating almost all unsecured debt, and that is just one of the exceptions. So there's a whole list under Section 529 of the Bankruptcy Code, and they're called exceptions to discharge.
Okay.
And the list would probably have some things on it that you might think common sense would say, of course you can't eliminate that in bankruptcy. That would be unfair.
Yeah.
So one of the top things that you cannot eliminate is child support. Sorry, no matter what.
Yeah.
If you owe back child support, you are not wiping that out in bankruptcy. And that's important. So that one I'm pretty much on board with, right?
Yeah.
And then, of course, the fraudulent usage, luxury purchases, some tax liability, criminal restitution if you commit a crime and rob a bank and you were supposed to pay back criminal or some kind of civil restitution.
That
stays with you.
Makes sense.
Makes sense, right? So the list does have a lot of things that make sense. Like I said, some tax liability, parking tickets were under that list. Debts owed to like a government entity kind of. You have to read it carefully. It's very complicated.
Yeah.
But student loans, right? A loan that was taken out for any educational purpose. Now, in order to discharge your student loans in Chapter 7, you or your attorney actually has to sue the student loan company and file what's called an adversary proceeding, which is essentially a lawsuit against Sallie Mae. Telling Sallie Mae, hey, listen, I know that you're accepted from discharge, right? However, having this student loan poses so much of an undue hardship on my life that I can never live a normal life again if I don't get this student loan discharged. But guess what? You're pretty much going to trial against Sallie Mae lawyers on that one.
That seems like a really tough standard to try.
It's a huge standard, and there's a test that goes with it. There's a case out there called the Bruner case. So essentially, you're looking at the Bruner test, which is what everyone looks at, and it's not in every jurisdiction, but here it's really tricky. You have to basically show that your standard of living is already so low and will never improve if you keep paying these student loans. It's really hard. So for my clients that are younger, able-bodied, smart, have decent jobs, you're pretty much not going to pass that test. You might pass the test if you are older, maybe you're over 60, maybe you took out these student loans for your kids, you live in a rural area, you're living off Social Security, and part of one of the prongs that you have to show is that you've also tried to pay this debt off and couldn't. So you have to really prove that you're kind of destitute, you just can't do it, and your situation is never going to improve. This isn't just I broke my leg and I can't work. This is like a permanent situation.
This is it. Yeah.
Now, it does happen. I'm not saying it doesn't. People can have student loans discharged. It's also very expensive because it's not included in the price of normal bankruptcy. Because I have to go to trial against Sally Mae. And stop everything else I'm doing in my life. So it's tricky. There are some attorneys that specialize in that. I've filed maybe 1 or 2 adversaries and lost both. And a lot of times if you can go on an income-based repayment, which is kind of unfair, but if you can go on an income-based repayment and pay $0 or pay $10 a month, the judges kind of say, well, just do that. But that's not fair, right? I mean, there's a huge push to include student loans in discharge. I know some of the past Democratic presidential candidates had talked about it. But we'll see. I think if you want my opinion, I think as a bankruptcy attorney, I think it's something that has to happen in the next 5 or 10 years. In some capacity, student loans have to be addressed. The bubble, if it hasn't burst, it's going to. And I think with the coronavirus, we can see that because right now, everyone's student loan payments are on hold. At least the federal student loans. And that's 3 months of people not making payments. So I'm not sure if people will be able to go back to making those payments.
Well, you're going to fall behind on all kinds of other stuff, right? Basic stuff to live. That's interesting. Okay, so I guess at the end of the day, it's not going to happen through bankruptcy. It's
not yet.
Unless you have very specific circumstances. You're not going to discharge your debt in bankruptcy. So the best thing you can do is talk to your representatives and
talk to representatives and get something done. And I always tell people too, at least now that you're filing bankruptcy and eliminating all of your other debt, you can focus on working on those student loans. So if people do qualify for Chapter 7, it's a pretty straightforward process. We file the case. Hopefully it goes through. You have your meeting and you're discharged. If you don't, you have to look at the Chapter 13 bankruptcy, which is a repayment plan. That one is much more complicated, but essentially what I tell people, it's a consolidation of your debt. So if you have $50,000 of debt, and maybe you have some assets that are not exempt and you don't want to lose them, you can do a Chapter 13, keep your assets, but you're going to have to pay back some of your debt.
I see.
And that's a range.
Like if you have some equity in your home,
a little bit of equity,
want to lose your home, but you're above the exemption. Then it's Chapter 13 if you want to keep your home.
And if you can afford it. Because the trickiest circumstances are my older clients. I have elderly clients who, unfortunately, their house is paid off. They might not have a mortgage, but they have $30,000 of credit card debt. So they don't qualify for Chapter 7 because of the equity, but they can't afford a Chapter 13 payment because they live on Social Security. So that's one of the trickiest situations with bankruptcy is finding a solution for them. Unfortunately, a lot of times that might be selling the home. Or just figuring out how to make that payment in Chapter 13 because the payment in Chapter 13 is based on 2 things. Your ability to pay, of course, your budget, your income, the tests that we run, and how much money is left over. But it's also based on your value of your assets. So once again, if you have a house that's paid off and it's worth $200,000,
that's going to push up your
payment because it's not fair to creditors that you own a home with $200,000 of equity and you're not paying your creditors the full $30,000 that you owe. So it's kind of up to the asset value is what you pay. So that's a little bit tricky.
So you're kind of almost have to sell your home, right?
Well, absolutely. Or risk that the creditors don't sue you and don't put a lien on your home because that's really the drive to file bankruptcy. If you do file for bankruptcy, it protects you from lawsuits and no one can sue you. No one can garnish your wages once you file. So that is a really good, it's a good way to protect your assets, but you have to be able to pay that payment in Chapter 13.
And how long is that payment until your debt is extinguished?
It's not. It's actually, no, the rules are 3 to 5 years. So Chapter 13 is literally a repayment plan between the minimum that you can do is 3 years. You cannot file a 1-year Chapter 13. You can do a 3-year to 5-year bankruptcy. Now, you can pay off your case faster if you come into money or if you win the lottery or something, which is rare. But normally, people's payments are a set payment, could be $300 a month. It could be $1,000 a month, right? If you make $150,000 a year, a lot of people, one of the questions I ask people is, how much are you right now paying in minimum payments on your credit cards?
Okay.
Right now. Sometimes people have no clue. They sit there and they're like, well, let me see. Discover card, I pay $200, American Express $300, and I can guess. I already kind of know. So if you have $20,000 or $30,000 of debt, I guarantee you're paying about $1,000 a month in minimum payments.
Yeah.
I just know. So I kind of tell people, I'm like, is it about 1,000? They're like, I think it's more. Almost always, a Chapter 13 payment will be lower than that. Just by definition, it's a consolidation of your debt. You might pay less than 100% of your debt. I might propose a 50% plan.
Yeah.
And the beauty of Chapter 13 is that it's almost always without interest. So what you're knocking off is all of the interest to your credit cards. It stops accruing the moment you file. So if you come to me and you have $60,000 of debt, that's it. It's not going up. The creditor files a claim and it's set in stone. And your payment might be a range of anywhere from 10% repayment to 100% repayment if you can afford it. But even 100% repayment is great if it knocks out interest.
Which is huge.
Yeah. So people think that people file bankruptcy and they come to me and they have no job and no assets and no income. And that's not true. I have plenty of people who have good jobs. They have a house, they have a car, they are just drowning in debt, credit card debt usually with the interest. And so once we propose a nice consolidation plan and I tell them, you know what, you can afford to pay something. Let's see what I can do. And I work I don't want to say magic, but it takes some time. I run the pay stubs. I run this test. I look at taxes. I look at their debt. And I come up, me and my software, we come up with a plan payment that I think will be feasible and that I think the court will approve. The court does have to approve that payment. And that comes with experience. So I might tell people, you know what, after I run all your numbers, I think we can propose a $500 repayment. How does that sound to you? Clients can agree, or they can say they hate it and they don't have to file bankruptcy.
So it's interesting. So it sounds like you almost shouldn't wait until you are so in so much trouble with your debt that, even before then you should start thinking about, okay, this is unmanageable. There's no way I'm going to get this stuff paid off.
Right.
Let's start thinking
Absolutely.
about that.
And bankruptcy planning is huge, especially now with the COVID-19, because you might have been unemployed for the last 3 months.
Yeah.
You might be living off unemployment or Social Security or no income or family help or part-time income. Maybe your hours got reduced. So a lot of times I also tell people, don't wait until it's too late. And when I say too late, I mean that your house has already been sold at a foreclosure sale. You've lost your car. Creditors have garnished your paycheck already, or the worst thing that you can do is cash out a retirement account to try to pay off your own debt. And I'm a member of a lot of Facebook groups and things like that, and I sometimes see such terrible advice. Especially in some of these groups where people aren't attorneys and they don't know bankruptcy law, and they think that bankruptcy is this thing where you're going to lose everything and it's going to be terrible. Yeah. And I see people, non-attorneys, give advice to people who are drowning in debt. Oh, just cash out your 401k. You have 50,000, which is exempt in bankruptcy, right? And then you cash out your 401k and you pay off your debt. Well, now you have no retirement. And sometimes people do it and they still have debt and still have to file for bankruptcy. I had it happen to a friend of mine who's an attorney. Her aunt came to me a couple years ago and she had cashed out about $50,000 of her retirement and still couldn't pay off her debt. And she still had to file bankruptcy.
Wow.
So that's very sad. I always think of these, my clients as, especially my Latino clients, as being like family members. Sometimes I'm like, what would I want my mother or my father or my cousin or my aunt or my uncle to do? And it would not be cash out your retirement. So those are things that
you think, okay, that's one of the few sources of money that a lot of people have.
Right. And they think that they have to use that to pay their bills, or they think that there's this moral stigma that I have to pay off my debts. I'm a bad person if I don't pay my bills. And that just doesn't make sense. Yeah. Filing for bankruptcy is a financial decision. Yeah. Right? It shouldn't be a moral decision, or it shouldn't be an emotional decision. I mean, the problem is that we're human beings and it's tough. And I understand that you've paid your bills your whole life and you don't want to not pay your bills, but it's not about that. I ask my clients all the time, okay, I understand that you don't want to file for bankruptcy, or, you feel very bad that there's a stigma that, oh my gosh, I didn't pay my bills. But when's the last time you went on a family vacation? How much money, and I ask these questions obviously pretty rhetorically, how much money do you have saved in your children's bank accounts?
Yeah.
Well, nothing. Okay, how much of term life insurance do you have? Well, we can't afford life insurance right now. I'm like, but you're paying $1,000 a month to your credit cards. So surely you can afford life insurance, but people just don't prioritize important things. So I always tell people, look, this is a financial decision. Banks and corporations file for bankruptcy all the time.
Right.
Chapter 11. Chapter 11 is a business reorganization. Banks do it. Corporations do it constantly. In fact, right now, if we Googled how many banks and corporations have, not banks, I'm sorry, corporations have filed businesses have filed bankruptcies, it's hundreds in the last month.
Yeah.
You know,
Well,
just
and I'm sure it's gonna. I think we're expecting in the fall probably a lot of businesses are gonna.
Yep. And
not gonna
I
make
actually was just looking at a New York Times article that's titled "A Tidal Wave of Bankruptcies is Coming." Now, this particular article refers to business bankruptcies mostly because retail spaces have been so affected by the closures, right? I mean, if you haven't been able to open in 3 months, you obviously are digging yourself in a hole. So a lot of this applies to business bankruptcies, but that's what I tell people. I'm like, look, Best Buy, did Best Buy file for bankruptcy? I'm not sure.
No, I don't think so.
But for example, Payless, I know they filed for bankruptcy. Do you think that the owner of Payless sat down and cried before he had to file bankruptcy, or did he or she make that decision motivated on how can I fix my situation?
Yeah.
What's the smartest way for us to survive, and reorganize? And that's what I tell my clients. I'm like, this is a decision that no one else can make for you. You're not going to be criticized by anyone. And by the way, do you think that the CEO of Discover Card is going to, be affected by your filing bankruptcy and discharging?
Upset
That's not how it works. That's not how it works. You file bankruptcy, and the harm is always to you, right? I mean, these businesses will survive, and the CEOs still make millions. So they write these things off as a loss on their taxes, and they'll be okay.
Part of doing business.
It's part of doing business, and you know what? It's the risk that these banks take for lending.
So earlier you said when you evaluate somebody, you ask them if they've filed for bankruptcy before. Why is that?
So it's really important because you actually can only file Chapter 7 every 8 years.
Okay.
That's it. Very simple. Every 8 years. So if they have a prior Chapter 7, and most people don't remember, I look it up on the computer, and they are not eligible. So then they might have to file a Chapter 13, you see?
Okay.
But with a nice low payment, hopefully.
And you can do Chapter 13s?
You can actually do a 13
whenever?
as long as you're employed and you have some source of income. There are different rules on refiling Chapter 13s, a lot more lenient because Chapter 13s fail often because people can't afford their payments. So you can have a Chapter 13 that goes on 6 months and then you don't make the payments.
Okay.
And you can refile another one.
To then say,
hey, I messed up. I lost my job last time, but look, now I can make my payments. And the judge reviews it and says, okay, go on. And you can do that a few times, not too many times. And there's rules about that. So I'm always looking at people's filing history. I might have a client who's filed 10 bankruptcies in the last 10 years. Wow. That's a little bit of a red flag. What's happened in the past and what makes you think this bankruptcy will succeed? So we always look at the past filings. Okay. But that's really the only reason, just for the rules. We're also looking at, whether they've done things with their money in the past, like transfers of money and things like that. So.
Okay. Yeah, you talked a little bit about this, but I think with the New York Times article in terms of on the corporate side, we're expecting to see a lot of bankruptcies. Are you seeing a lot of bankruptcies now, or do you expect like a bunch to come pretty soon?
I expect in the next, and this has kind of been a discussion we've had with other bankruptcy attorneys and friends, we do expect people to really start considering bankruptcy in the next few months. I would say maybe fall or winter even, because what happens is this might not be the best time for people to file because life is kind of on hold, right? We're starting to open up, at least here in Illinois. Right. Restaurants are starting to open up. Some haven't survived. Some haven't made it. Right. And people have been kind of on unemployment. We've also had this moratorium on mortgage payments, rent payments, credit card payments, and student loan payments. So
those are running out.
Those are running out soon. I think at least by August on student loans, I believe. I'm not sure about the mortgages, but it's all going to end soon. And what we want to know, especially as bankruptcy attorneys, is what does that mean for you when August and September hits? is your mortgage company going to tack those 3 months of missed payments to the end of the loan? Because I promise you that they're not just going to forgive those payments, right? Because you signed a mortgage contract.
Right.
So that mortgage contract they're basically altering that. The mortgage company is altering that contract and modifying it. And we want to know what's going to happen. So are these payments all going to be due? Well, that would be very unfair.
Like a balloon payment,
right?
Or
Like a balloon
like
payment.
That, yeah.
So we need to know more about what's going to happen before we know whether people are going to start filing. But I can tell you that I've already had a little bit of an uptick in interest because bankruptcy takes so much planning. I do have people thinking, "Gosh, I'm okay right now, but I'm not going to make it another month." Yeah. You know, and so we need to see if people are going to get back to work, what kind of income they're going to have, and at that point, some people are also prioritizing things differently, which is good. Yeah. Maybe after 3 months of not paying your credit cards, you're realizing, I don't think I can go back to this. Yeah. So that's something that people might want to consider. You know, you've made it this long, but when you come out of this pandemic and you realize that you barely have enough money to pay your mortgage and your food and your car payment, that might be the time to consider.
I mean, what's so tough is that we don't know how that's going to play out, right? So it's kind of like, all right, I think it's getting better, but, you know, we look at Texas, we look at Florida, you see this kind of, you know, thing getting out of control. They're having to shut down again.
Exactly.
It's such a difficult time to
it's
kind
so
of try
difficult.
to plan.
It's a really difficult time to try to plan. So I just give people my best advice, and I have some links on my website and things like that. The best advice is to prioritize, right? We're in a pandemic. I mean, we're in a global pandemic. This is the time to prioritize the things that are important in your life, which is obviously spending time with family, you know, being safe, staying healthy, and only paying the things that you can afford to pay. You know, when people spend less, banks are also maybe lending less, right? So we have to see what happens with banks, whether they're going to be lending again, whether credit cards are going to stop extending credit as they have in the past, you know, things like that. So there's a lot to think about, but I do think that foreclosures, and court cases have also been stalled.
Yeah, I was going to ask you, what is a court system
So
look
the
like
court
right
situation is difficult because if you were being sued for a credit card debt back in February, actually you got kind of lucky because that court date is being continued March, April, May, June. We're not even seeing these court cases until July or August. Okay. So some of my clients get these little postcards in the mail for a lawsuit, and they don't have to even go back till July or August. So that's another determining factor. I mean, if creditors aren't bothering you, so to speak, there's no reason to file right now. But come August, when that wage garnishment will go into effect, then you might have to consider filing. Same thing with foreclosures. Foreclosure sales have been stopped. That's huge because Chapter 13 actually saves your house from foreclosure. So if you're behind on your mortgage, $20,000, $30,000, and you're in foreclosure, you can actually file Chapter 13 to save your home and repay back what you're behind in that 5-year plan.
Oh, interesting. Okay.
Yeah. So a lot of people call me on the eve of a foreclosure. Their sale is going to happen Monday and it's Friday. We can file and save the home. But there's no need to rush and do that if there's no foreclosure sales. Yeah. So a lot of this is coming because this, you know, they're holding off a lot of these collection actions and foreclosure sales, but not forever. So I think when we find out that the foreclosure sales are rescheduled, that's when people really have to decide what they're going to do, or they're going to lose their home.
So if somebody is on the bubble kind of and they think that they may need to, what are the things that they should be doing? It seems like they should organize
Definitely.
all their papers and stuff like that. Like, what do you...
So I always tell people to start with looking at your credit report. If you know how to access your credit report, you can do it online for free. I think you can go to annualcreditreport.com. That's like the free one. And you can get your own credit report. Do a budget. So many people, it's like
figure out, here's what I need for this, this, and this. Yeah.
What kind of income do I have right now, and what can I pay, and what can't I pay? I tell people who are more advanced to make spreadsheets. Sometimes people make nice spreadsheets for me with their debt, the balance, minimum payment. Debt, balance, minimum payment, and then we can add up what they have, and we can say, look, if you didn't file for bankruptcy, what would be your plan? How are you going to get out of this debt? And people tell me, well, I'm making my minimum payments. I'm like, okay, that's great. But if you look at your credit card statement at a 17% interest, your minimum payment will pay off the debt in, does anyone know? 25 years.
Okay.
It's about 20 to 25 years. And your credit card statement will tell you that. That's new as of a few years ago. If you look on your credit, and it's in English and Spanish, you look right on that credit card, it'll be like, it tells you how much interest you're going to pay and when will you pay off the debt. So I tell people that's not a good plan.
Yeah.
You've been making minimum payments for 3 years now,
Yeah.
and your debt hasn't gone down.
Right.
And it won't for
Right.
20 years. So if you want that to be your plan, that's great. You're on a 20-year plan to repay your debt. But that's silly, right? So
It
that's
makes no
kind of what I
sense.
tell people.
Yeah.
What can you do yourself if you're not going to file bankruptcy? Now, some people can, get on this really tough repayment, and they can triple up their payments, and they can make themselves a plan and get out of debt in 3 years. That's great. But unfortunately, things are also going to suffer. You might not have any money in your savings account during that time. You won't go on vacation for 3 years. I mean, if that's okay with your family and your life.
And better
then
help nothing unexpected happens, right?
That's
always-
the other problem, right?
Yeah.
Unexpected situations. So many people think that people just file a bankruptcy because they're bad with money, or they're just frivolous spenders or whatever. And sure, there's a little bit of that. But quite honestly, it's rare for me to see a client who just files bankruptcy for fun. It's rare. People file bankruptcy because life has gotten so difficult. They can't keep up with their payments.
Yeah.
Someone passed away. They lost their job. They lost income.
They got sick.
They got
right?
sick.
Given
We didn't even
our
talk about
system.
medical bankruptcies. They had insurance
Yeah.
and still had to file bankruptcy because they were at an out-of-network hospital, or, their insurance lapsed for 1 month, and that's when they got hit by a car. They don't have enough policy high enough policy limits on their car insurance. You get into a car accident. You have insurance, but you have the bare minimum in Illinois.
Right.
And all of a sudden you hit someone and they're very injured and they're suing you for $100,000. Well,
And
my
your-
clients
and
are
your
like, but I
policy
had
won't cover it."
insurance. Well, your policy limits are like $15,000,
Yeah.
according to Illinois. Sure. That doesn't cover anything anymore in a
Mm-hmm.
hospital. So that is literally another situation that I had yesterday. Someone called me. Their son was driving their car. It was a husband and wife, and the son is like 16. He wasn't on their policy. Still, I think some was covered, but they had these bare minimum policy limits, And so the other one of the passengers of the other car that they hit, who was injured, is suing not only her driver, she's suing my client's driver, who's a 16-year-old kid. So next they're going to sue my client because he's the owner of the car. So, and that could have easily been solved by paying an extra $10 a month to get better policy limits on your insurance.
Right.
So those are things that people don't think about. They just want the cheapest, but you don't want the cheapest car insurance when you get into an accident, right? So things like that are things that kind of, they flow into my conversations too, that I'm discussing with people, making sure people have insurance.
Yeah.
Life insurance is important. And again, just making sure people are prioritizing the important things to pay. And unfortunately, credit cards are not, important.
To be at the top of the list,
They should not
right?
be at the top of your list if you can't afford it.
Yeah.
Like I said, I'm not condoning people running out and racking up credit card debt. In fact, you can't. It's fraud and bankruptcy. And if you can carry a credit card balance and live comfortably and still handle the basic, financial, your basic finances and pay your rent and your car payments and help your kids have savings accounts and retire, then sure, carry that credit card balance. But it's the people that come to me are overwhelmed. I mean, we have people with $200,000 of credit card debt.
Wow.
People don't come to me because they have $1,000 of credit card debt, right?
Right.
People come to me with major problems. And so that's what bankruptcy does. It will solve your financial problems.
So if I'm going bankrupt, how do I pay for a lawyer?
Well, that's a good question. So it's tricky. Unfortunately, Chapter 7 attorneys have to get their fees up front. It's actually a kind of a law here because we're not allowed to collect fees after the filing. So,
Oh, interesting.
yeah, so
Okay.
I
you're
mean,
not part of the bankruptcy estate.
in the Chapter 13, we are. That's a good question.
interesting.
So if
Okay.
my client makes payments over time,
Yeah.
I can charge less upfront because I will get paid from their payment.
I see.
But in Chapter 7, you're one and done, right? You file bankruptcy and you're done. So there really isn't any money to pay. So I try to keep my fees low. And I honestly, sometimes I tell people, give it 1 or 2 months of not paying your credit cards, and I bet you'll have the money for my fees.
Yeah.
So that's something I tell people to do. And like I said, a lot of this is planning.
Right.
People usually don't call me and file bankruptcy the next day unless it's some emergency, right? Emergencies are like wage garnishments or foreclosure, sale on their house, or their car was repossessed. Those are emergencies in bankruptcy world. Nothing else is an emergency, right? It can wait. So, and like I said, people come to me after thinking about this. People also have been paying on their debt for years before they come to me. So this isn't a decision people make lightly. It rarely is. Usually people have long paid off the principal on those cards, and they're just dying in interest. They're just paying interest. And so at that point, when you don't see how you're going to get out of that situation, that's when we look at bankruptcy. So it's tough. I mean, you know, we do try to keep our fees low. And I do try to work with people, but usually it's a few months before people can file with me, a month or two, and they hopefully save up the money.
Okay, that makes sense. Assume you didn't know any lawyers, assume you needed to file for bankruptcy, how would you go about finding a bankruptcy lawyer that you think is going to be good? Like, what questions should you be asking?
So, you know, one of the biggest things, and that I hear, especially from my clients, are referrals. You know, in almost any type of business, I think referrals are so important, in reviews. And in bankruptcy especially, talk to someone, you know, who has used that bankruptcy lawyer. How attentive is the lawyer to your concerns? You know, if you call a lawyer and they don't have time for you and they don't never call you back, I mean, I get clients who tell me, I called this other lawyer, you never call me back. And so communication is huge, especially for me. If I was going to file bankruptcy, or if I was going to have a will done or needed an attorney, I would want that attorney to communicate with me clearly, directly, in a timely manner. You know, do they have a nice website that I can look for questions answered? Are they vetted by other attorneys, for example? So sometimes people are referred to me by other attorneys and professionals that know me. So I would always want to know where, you know, who has used this attorney before, and recommendations and referrals are huge. So that's personally my experience.
Does it make sense to talk to multiple lawyers?
It does. With bankruptcy, you know, there's not too much you can shop around with. Fees are usually pretty set. You know, attorney's fees are not, you're not going to find one lawyer who charges $10,000 for a Chapter 7, right? It's almost always around $2,000, no matter where you go. So shopping around for people usually has more to do with their comfort level, the location of the office, how much is done virtually. I have clients who love virtual appointments. I have clients who hate virtual appointments. As an attorney, you have to be flexible. Do they want to meet in person? Can we even meet in person right now? Is it safe to meet in person? Can we do things virtually? Some clients are comfortable with that. Language, of course. I speak Spanish fluently. So, of course, that's very helpful, because people don't feel comfortable communicating in a language if they don't understand some of the legal terms. But yeah, I think that making sure that the attorney has a good presence online as well. I was just listening to a webinar the other day, or watching a webinar about establishing your presence online, and making sure that when you Google that attorney, that you can find their website quickly, find out how many years they've practiced. You know, there's nothing wrong with going with an attorney who's new, right? Attorneys are kind of like a doctor, you know, everyone has to learn. But experience counts in bankruptcy. Do they file bankruptcy cases often? Is this their specialty? And that's pretty much all I do is bankruptcy. So that's something I would want to know. I'm not sure I would want an attorney who dabbles in bankruptcy. I would want an attorney who's done this 1,000 times before, you know? And so that's important, I think.
That's huge. Jody, do you have any questions?
I do. Most of them you actually answered through the course of the podcast, but one big one. Can you file bankruptcy on taxes?
That's a great question. So technically, yes. So you can file bankruptcy on anything. So one of the big things that people don't realize is when you file for bankruptcy, you have to list all of your assets and all of your liabilities in this petition. You must do it. So if you tell me you owe the IRS, you list it. Because it's listed, it doesn't mean it's going to get discharged. So once you list that debt, my job is to figure out how old the tax debt is. So there's rules. It has to be due over 3 years ago. Okay, so those are tricky. Those are basically, your attorney should figure that out. But if the tax is old, assessed by the IRS over 240 days ago, so old, and the IRS assessed it, and you filed your taxes over 2 years ago. So you can, the short answer is, if it's regular 1040 taxes, like you just, you know, owed money on your taxes, nothing fraudulent, nothing willful, no tax evasion, right? Normal tax debt, For an individual, corporate is different.
Yeah.
We call them 1040 taxes essentially, and they're within 3 years. You cannot discharge them in bankruptcy. So you're going to have to go on a payment plan with the IRS. If they're old tax debts, older than, say, 2015, 2014, 2013, and they're plain old tax debt, they were assessed a while ago, you file the taxes on time, and we can determine all this by looking at your tax transcripts. Okay. Then they are dischargeable. So the trick is you list everything, and then you wait until the discharge and then discuss with the IRS what's left and what's not left. And actually, filing bankruptcy for taxes is huge because I constantly file bankruptcies for people with over $100,000 of tax liability.
Ouch.
Some of it is dischargeable, some of it may not be. And that's also determined in the Chapter 13, the way that you pay the debts. There's priorities to things. So some tax liability, yes, some no.
Interesting. I don't think we covered this. You may have touched on it. Does filing bankruptcy like unfreeze frozen bank accounts?
Absolutely. That's a great question. As long as you do it before the creditor has actually taken the money. So there's steps to wage garnishment and there's steps to bank levies. So a credit card company and remember, this is after you haven't paid for like 5 months. Right. So you stop paying your credit card, you're bothered, phone calls, collection, attorneys, lawsuit, right? We're talking maybe 5 months. It depends. Some credit card companies work faster than others, and some won't sue you for a year. So we'll see. But once you've been sued and that clock starts ticking and they file their, their complaint and the summons and you're served with it by a sheriff at your door and you don't appear and you don't go to court and they get a judgment against you. Yeah. They enforce that judgment by they can put a lien on your bank account. And there's a court date. There's a citation to discover assets. There's all these court dates that go along with it. And once they have that freeze on your bank account, there's another court date when they go and ask for the money to be released.
Got it.
I always get the call at the freeze part.
Right.
I should have gotten the call 6 months ago, but I get the call at, oh my gosh, there's $5,000 in the bank and they're holding it. And what do I do? I'm like, well, now you do have to file bankruptcy and quickly. Right. Because I got to get in before the next court date, and then yes, the funds can be released. Not all funds. Remember how much money was in the bank. Right. Was it $20,000? Because that's not exempt in bankruptcy, so you're going to lose some of that. Yeah. If it was 4 or 5, it's usually not that much money. Right. Honestly, people who have $20,000 in the bank aren't usually, and then not always true, right? But as a general rule, my clients don't have $20,000 in the bank. Yeah. Usually it's $1,000 or $2,000. And of course, the advice immediately is stop using that bank. Stop your direct deposits. Don't touch that bank account. Leave it be. And then file bankruptcy and we can unfreeze those funds.
Got it. Mm-hmm. And I know you had touched on that, parking tickets can be gone through bankruptcy. Say your car is impounded.
It's a great question too. Yeah. And so this involves lengthy fights with the city of Chicago. It's usually the city of Chicago, right? Let's face it. So there has been every couple months there's an opinion issued. An opinion is basically something that a judge writes about an issue that's come up before him or her. So a judge will write an opinion saying this is what has to happen, this is the law. And so there's been a bunch of opinions with City of Chicago impound issues. And the judges are split in this jurisdiction, but essentially, yes, you can get your car out of the impound if you file for bankruptcy. That's the long story short. It's a little bit of work.
It's not going to be easy.
It's not going to be easy. You have to fight a little with the city. It also depends what your car was impounded for. So like any good lawyer answer, it depends. Right. If your car was impounded for drugs, no. If it was impounded for DUI, no. Illegal criminal activity, sorry, goodbye to your car. Yeah. But unless you win the case, of course, right? Sure. But if it's impounded for like tickets, yeah, you can get the car out of the impound. And if it's repossessed for not paying your car payments, you can also get it back, but in Chapter 13 bankruptcy, because you have to repay back what you owe the finance company. Right. So it's tricky, but yeah, car impounds are big, although of course with the coronavirus, we're not seeing impounds right now. Yeah. Boots on the car. Right. That's a fun one. You have 24 hours to file bankruptcy before the car gets impounded. And then once that boot hits your car, I have literally filed a bankruptcy at 11 p.m. at night for someone because I wanted to file it before the car was impounded. Now it did get impounded, but I filed the case before the impound when the boot was still on, so it came back faster. Wow. It's tricky, but yeah.
Yeah, I've had 2 boots since I've lived in Chicago.
Yeah, it happens.
One
it
was
happens.
very recent, as
Yeah.
a matter of fact, and I had to pay tickets on a car that I sold.
It's ridiculous.
6 years
right.
ago or
They'll
something.
boot your car for tickets for another car. People
Right.
think they're only going to boot your car because that car has tickets. No.
had no idea.
They'll boot your car because you're on the boot list. Wow. So you get off the boot list with bankruptcy.
Right. So now, I file bankruptcy. Will that stop creditors from calling my home, work, relatives, all that stuff?
And that is one of the best. That's one of the major reasons people file, for peace of mind. The moment I click that button and your case is filed and you're assigned a case number,
Yeah.
you are protected by what's called the automatic stay. Stay is in the word like stay away.
Okay.
And that stops. That's your magic bankruptcy protection that protects you from creditors calling, harassing, looking at you, emailing you. Now, creditors don't get notice for a few days because, of course, the bankruptcy
Right.
court literally mails them your information and your notice. So once that creditor gets it in the mail, so it might be like a 3 to 5 day window where you're still getting called. But then I tell people, go ahead, pick up the phone. Pick up the phone, and all you have to say is, I filed Chapter 7 bankruptcy. I give them a script. My case number is 20-12345. My attorney is.
Right.
Please call my attorney, and they have to accept that. Now, they can ask for a fax, a courtesy fax. And if I have a very, very harassing creditor, like a lawsuit, I almost always, as a courtesy, call the attorneys and fax them notice. Remember, we're dealing with the same attorneys on collection matters over and over again. And I know who they are, and I know their fax number, and I have their email. So as a courtesy, if my clients are being sued or in litigation, I immediately, that moment that I file their case, I send them a template notice letter saying, hey, just so you know, John Smith has filed bankruptcy. You are suing John Smith under this case number. Please immediately dismiss any and all lawsuits against John. So,
Yeah. And then how long after I file bankruptcy can I get a credit card?
Honestly, pretty fast. So what happens is bankruptcy is a public filing, it's public information. And so creditors can find this stuff out, and most creditors actually check your credit often. So a lot of people think that, and we didn't talk about this, but a lot of people think that they can file bankruptcy and keep that one Capital One credit card they love so much. Well, if you have no balance on it, you can try to keep it. I can keep it out of the bankruptcy because you don't owe them money, but most likely they're going to close your accounts because they know that you filed for bankruptcy. You don't think they get credit alerts on you? They do. And so that account might be closed, but it's also public knowledge that you file bankruptcy to other credit cards. And there's some kind of higher interest credit cards with very small credit limits that are out there that will give you credit cards after you file for bankruptcy. And I have people call me and they're like, did you know that I got 3 credit card offers this week? And I just filed bankruptcy. How do they know?
It's part of the business model.
Part of the business model.
Right? Yeah.
Because guess what? They know that you can't file bankruptcy for another, 8 years. Now, I encourage my clients to not get credit cards after they file bankruptcy. But 1 or 2 credit cards might be okay. Your balance is, your limit is going to be pretty low. You're not going to get approved for a $20,000 credit limit, nor should you. But you might get approved for a $500 credit limit. And that might be all you need for an emergency. Because people always tell me, oh, I need a credit card for an emergency. I'm like, you need an ambulance for an emergency, not a credit card for an emergency. And there's also secured credit cards that you can get that actually build up your credit, but you can only spend the money in them, kind of like a debit card.
Basically, you put in.
Yeah, you put in what you can
money.
spend, but it's not a debit card. Because debit cards, usage of debit cards doesn't report on your credit. So if you want to see your credit improve after bankruptcy, you want to see a positive pay history on your. That's what creditors want to see. People who lend to you, they want to look at your credit report and see that you've been paying this thing for 1 year. Most of the time, that's a car, a mortgage, a credit card, student loan.
Yeah.
So you can build up your credit by maintaining mortgage payments, maintaining car payments, things like that.
Interesting.
One small credit card.
Will filing bankruptcy stop me from getting evicted?
So that's a tricky question. The short-term answer is yes, because it stops all lawsuits. However, if you want to stay in the apartment, most of the time you have to pay at least the ongoing, the rent that's coming.
Moving forward.
Yeah, moving forward. And a lot of people can't do that anyway. So it does stop evictions, and you can assume or reject leases in bankruptcy. So if you've assumed a lease, usually you have to maintain payments on that lease. In Chapter 13 bankruptcy, you can do a lot more because you can repay back that amount that you're behind and stay within the lease terms.
So that's kind of you mentioned earlier this idea, hey, just because you filed for bankruptcy doesn't mean that now you don't have a
No, you don't.
mortgage
No,
payment.
absolutely.
It's only addressing the stuff that you're behind on.
Exactly. I always tell people it's like a timeline. It's
Yeah.
it's a point in time where you file bankruptcy. Everything before gets discharged with some caveats, and everything after is your responsibility. So new usage on a credit card, which you shouldn't be doing at all, but new utility usage, association dues in a condo, those are all ongoing debts. And you can be evicted from your condo for not paying condo association dues. And that happens way faster than a foreclosure. So a lot of people file bankruptcy to save their condo from the homeowners association taking over. So
Interesting.
yeah, it's tricky. There's a lot that can happen, but usually you have to repay what you're behind.
I have one more. You already talked about, I believe, child support, right?
Yep.
You can't file for child support, right?
Right.
Alimony. Can you file
Same
for
thing.
alimony?
Child support and alimony you can't discharge.
Same
No.
thing.
But there's a whole other type of discussion, that has to do with like divorce attorney fees and property settlements. So property settlements are treated differently.
Yeah.
Usually you can't discharge in that in Chapter 7, but you can in Chapter 13 and repay it over time. So those are very nuanced types of those are in the exceptions to discharge, right? In 523A, 5 and 15 or something, it's like child support and alimony. Yeah, so you can't discharge that either.
I did have one more question.
Sure.
So sometimes, especially in low-income areas, parents might get a credit card in a child's name or get a bill in a child's name.
Yeah, it's
Can a
happened.
kid file bankruptcy?
So minors that I know of, minors cannot file bankruptcy. I'd have to look at the bankruptcy code to look.
Not
that
too many
one up.
kids calling you.
No, but yeah, not too many kids. But I do have very young people who've had to file bankruptcy. So I don't think you can be a minor.
Okay.
That's a good question. That
Interesting.
one stumped me. I'm not sure if you can file bankruptcy. Now I'm going to look it up. That's going to drive me crazy. But I don't think you can
There's
file
an area of the
bankruptcy.
law you've got to expand into.
Minor bankruptcies, yeah. But what can happen is you can have to file bankruptcy due to identity fraud issues.
Right.
So you might be 25 and you've never done anything with your credit, but you realize that your mom has been using your credit for 20 years or whatever. Now, you could sue your mom. You could open a police report, a police investigation. You can handle that individually with every single creditor and fight it for the next 10 years, or you could just file bankruptcy. So I've unfortunately had to file bankruptcy cases for people who just gave up the identity theft fight because they still were on the hook for all this debt that they didn't incur. And I'm like, look, I'm not your lawyer for that. If you want to fight that, you can file a consumer fraud complaint with the Attorney General. You can fill out forms, but you're going to be doing that for a year or more.
Right.
Sometimes, unfortunately, the solution is bankruptcy. Car accidents is another one we didn't talk about. But if you have a judgment for an unpaid car accident because you didn't have insurance, the state of Illinois can suspend your driver's license. And I'm not talking about parking tickets. I'm talking about you drove a car with no insurance and you crashed into a light pole.
Yeah.
And you damaged city property and it costs $10,000 to replace that light pole. That's property damage, right? And that can be discharged in the city, or you hit another car, usually you hit another car, and you get sued. And unfortunately, State Farm is suing you, but you don't have insurance. So you owe them $20,000. So that's an unpaid car accident judgment. And that can be discharged in Chapter 7, and you will get your license back. I've had people with their license suspended for 5 years due to an unpaid accident. Uninsured accident. So, you have to get SR-22 insurance, you have to pay a reinstatement fee, but the debt itself is wiped out. So that's a really big one. And that, unfortunately, is the cause of a lot of younger people who do file maybe in their 20s. They don't have credit card debt yet. They're only 21, but they have the ability to drive. So once you have that ability to drive, you have to be very careful that you're insured and that you have good insurance limits so you don't have to file bankruptcy.
Cool. I think that's all the questions I have.
Okay, great. Okay, one more for me.
Sure.
So on the podcast, we always talk about, hey, if you think a law is unfair, it doesn't make sense, that hey, you need to organize, you need to vote, you need to get people in who will change the law that you think needs to be changed. Is there any area in the bankruptcy context, having practiced in for so many years, that if you could change, you would change?
Oh, absolutely.
Yeah.
Oh, I can answer that quickly. Number one, student loans should be dischargeable in bankruptcy in some capacity. People always moan and groan that, well, it's not fair, I paid off my student loans. I'm like, well, that's very nice, but that doesn't mean that the injustice should continue for 5 million other people. Just because you went through something that was unjust and unfair doesn't mean that should continue for other people.
Yeah.
It was very unfair that you had to incur $70,000 of student loans to get a job that pays $40,000 a year.
Yeah.
So, and everyone's situation is different. And of course, if you can pay your debt, generally you should pay your debt. But it's not a fair system because education shouldn't cost that much. If you look across the globe, America is doing it wrong. It shouldn't cost me $100,000 to go to undergrad and another $150,000 to go to law school. And I come out with $200,000 of loans and I'm making $50,000 a year. That ask a child. That doesn't make sense, right? So institutionally, it's a broken system. Now, are we going to change the system? Like you said, sure, we should change the system. College should be free or whatever. It should be a scale, and student loans lenders shouldn't be able to lend you $50,000 at age 18 when you don't know what that means. So that's a whole other issue. But barring changing the system, which, takes time, what they could do now is change the bankruptcy law. That doesn't take time. Right? I mean, legislation can move fast, and we've learned that with the coronavirus. So people that say, oh, that can't be done, stimulus checks came out. I thought we didn't have $3 billion.
Yeah, we got the CARES
but
Act.
we got the CARES Act. Yeah. We have a lot of different acts that came out. So it can be done. It just, lobbyists choose to not have it done. So that's a huge one. And when I say student loans should be discharged in bankruptcy, I don't necessarily mean that you should just wipe them out in Chapter 7 if you make $150,000 a year.
Yeah.
I think that in some capacity, maybe they should be discharged only in Chapter 13, where you pay a certain amount based on your income and your ability to pay, and then whatever is left is discharged, like everything else. It's not a life sentence. That's what I think should change. Another one is eliminating what's called this means test. That's more nuanced, but that just means that, they're really looking at these 6 months of income. I think that should be eliminated. I think it should be just looking at their income and expenses at the time of filing. Okay. Credit counseling, people have to, before you file for bankruptcy, you have to do a credit counseling course. It's silly. It came out in 2005. People, credit card companies lobbied for it. They were like, well, people need to, they need to do a credit counseling course before they file. Okay. That course costs $15, which is a hardship for some of my clients, by the way. And it's like an hour test where you have to sit there, input all of your income, all of your expenses, and it gives you advice based on your budget. Well, the people that come to me have already made the decision to file bankruptcy. Right. And this credit counseling course, no, they're not attorneys, right? I don't think they should be giving my clients advice on what to do. And sometimes that course is like a slap in the face to people because they're like, oh, have you tried reducing your car costs? And my clients are like, what? I have $100,000 of credit card debt. What do you mean reducing my transportation costs will help?
Almost like shaming.
It's a little bit of shaming. And, honestly, I think that money goes to, it goes to someone. It goes to these companies that I heard are like subsidiaries of credit card companies that started these companies that have to be government approved. So that's a huge hurdle to my clients, especially, guess what? To my lower income and Spanish speaking clients. And it's almost always people who are inconvenienced by this the worst. Because if you're 25 years old, 30 years old, and I tell you to click a button and do an online course, yeah, sure. Boom, 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 you're done. Yeah. Still takes you an hour. It's still a pain in the butt. But you can do it. You're competent. You're internet savvy. Who is it going to affect? It's going to affect my immigrants, my people who don't have computers, my clients who have to do this course on a little smartphone and they can't scroll through it and they need help with it. And it's just a huge burden to me because I have to go into my office and sit there with a client and help them all to get a certificate that says, congratulations, now you can file bankruptcy. That should be eliminated, and there's actually judges in this jurisdiction who agree. So maybe it was a good idea, but in practice, it's a terrible idea. And there's 2 of these courses, one before you file, and then you don't get discharged until you do the second one. Second one I've heard is a little better. It's a debtor education course that kind of teaches you how to manage your credit in the future. Maybe keep that course, right? But the pre-filing course, in my experience, serves literally no purpose other than a hurdle and a cost to clients. So those are my 2 big ones. Student loans. should be discharged in
Yeah.
some capacity.
Yeah.
It's just not fair, and it doesn't make sense that other debt is discharged and student loans aren't. What makes student loans special?
Right.
So.
Yeah. I think, I don't know what the polling is, but I think if you were to poll Americans, I think the
Especially
vast
now,
majority of
and
Americans-
maybe if we polled them last year, they wouldn't agree. But let's poll people in September when they haven't been paying student loans and they've been able to do something else with that money. And see what people think in October.
Yeah.
So.
Yeah. And at least there's some argument that kind of having this, all these loans out there has really increased the cost of education,
Absolutely.
right? Because now everybody, you can easily get, like you said, 18 years old, 50 grand.
Yep.
Here you go, because there's no risk
Well, and not only
in giving an 18-year-old.
Absolutely. And the other thing is,
50,000.
it's really not a fair system. I mean, at 18, what if you do want to change majors? What if that wasn't the best decision you made? What if you change your mind and you want to go to medical school and not law school? I mean, these are big decisions for very young minds. And
Right.
so I think that community colleges should be used more. And I think there was a push at some point, maybe the past mayor said they should be free or something.
Well, Chicago, if you have, I think, a B average, like your community college is free.
Oh, okay. Well,
So,
that's
at
that.
least you get your first 2 years, which I think.
Oh, that's great. I didn't know that had passed.
perfect
So
sense.
yeah, things like that are what we should be focusing on. But that's a whole other podcast, I think.
Yes.
Talking about our educational system in America. Yeah.
Yeah. All right. Well, thank you very much
Sure.
for the very enlightening conversation. This has been great sitting here talking to you. If somebody wants to get a hold of you, what's the best way for them to do that?
Quite honestly, the best way is probably going to my website, which is maybe you guys can post a link later, but it's www.badillolawyer.com. It's my last name, Badillo lawyer.com. They can also call me. Honestly, I pick up the phone all the time. That's one of, like I said, that's one of the things that kind of distinguishes me is that I make sure to communicate with my clients. I try not to answer the phone after a certain time, but, I do very well with communicating with people over the phone. So they can just call me, 773-716-7736.
Wonderful. Thank you so
Or
much.
email, but I can be reached on a variety of different platforms.
Okay. Cool. Wonderful.
Sure.
Thank you. Thank you for listening to the Isn't That Legal podcast. Please be sure to follow us or subscribe on YouTube, iTunes, or anywhere else that you listen to podcasts. If you have any questions or areas of the law that you would like us to explore, you can email us at itlpodcast@outlook.com. Remember, laws can change. If there's something that you think is unfair, you should do something about it. Thanks again for listening.